Good afternoon. Welcome to the Heritage Foundation and our Douglas and Sarah Allison Auditorium. And we, of course, welcome those who join us on all of these occasions on our heritage.org website and remind our Internet viewers that they are welcome to send comments or questions at any time, simply emailing speaker@heritage.org. For those in-house, your only immediate task is to check as a courtesy that cell phones have been turned off as we prepare to begin. It is always appreciated. We will, of course, post the program on the Heritage homepage following today's presentations for your future reference as well. Hosting our discussion is Alden Abbott. He is Deputy Director of the Edwin Meese Center for Legal and Judicial Studies, as well as serving as the John, Barbara, and Victoria Rumpel Senior Legal Fellow. Prior to joining us here, he was a Director of Patent and Antitrust Strategy for BlackBerry. He has held a variety of senior government positions. He is also an adjunct professor at George Mason Law School, a member of the leadership of the American Bar Association's Antitrust Section, and a non-governmental advisor to the International Competition Network. Please join me in welcoming Alden Abbott. Alden?
Thank you very much for that kind introduction. 4 years after passing a major patent law overhaul, the America Invents Act of 2011, Congress is considering a major new piece of patent legislation. Supporters of the legislation claim that it would reduce costly legal burdens, rein in patent abuses, and promote innovation. In particular, supporters are concerned that so-called patent trolls, or patent assertion entities, firms that acquire patents to assert against third parties and don't themselves innovate, have engaged in costly and excessive litigation that has raised costs and slowed innovation. Opponents of legislation argue to the contrary, that new legislation would devalue patent rights and slow innovation, and patent troll activity either is not a source of serious harm or can be handled adequately under existing law. The outcome of this debate will have major significance for the American patent system and the economy. We're pleased you are joining us today to hear as experts on patent law and policy debate our important topic. Arguing in favor, we're going to have 4 speakers. Now, arguing in favor of legislation are Professor Michael Muir of Boston University, a lawyer and economist who has written a great deal on the patent troll issue, and Jessica Halbert, Associate General Counsel at QVC, Inc., who leads that company's intellectual property legal team, including personal oversight of all patent assertion entity litigation. Arguing against legislation are Professor Kristen Osenga of the University of Richmond Law School, who has published extensively on IP law and patent law, and the Honorable Paul Michel, former Chief Judge of the U.S. Court of Appeals for the Federal Circuit, the Federal Appeals Court that hears patent disputes. And by the way, there are biographies of these 4 distinguished speakers available to you. We'll proceed as follows. Each speaker will make a brief statement about 8 to 9 minutes long of their respective positions in a pro-con sequence following this order. First, Professor Muir will speak about the merits of legislating, to be followed by Professor Osenga, and then Associate General Counsel Halbert, and finally Judge Michel. We will then have about 10 minutes for short comments by the 4 speakers responding to what they have heard. We'll then have up to 15 minutes for free-flowing roundtable discussion among the participants, and leaving roughly 15 minutes for the audience questions. And all I need to say now is let the debate begin, and I will turn the microphone over to Professor Muir.
Would you like me up there or here?
Perhaps up here would be fine. It's up to you.
Thanks, Alden, and thanks all of you for coming today. Our patent system works well in some ways and poorly in others, and that's not surprising. The goal of the patent system is to create property-like rights, and that's difficult for something intangible like inventions or information. Pharmaceutical patents behave like property and stimulate pharmaceutical innovation, software patents are a disaster. An innovator, an innovative firm that wants to incorporate new software into a new car, a new coffee pot, a new web server, or a smartphone, cannot reliably identify what patent-based property right could be asserted against it, who owns the rights, and what the scope of the rights might be. As a result, we see a flood of opportunistic patent assertions that impose a tax on innovation. Virtually none of the losing defendants in patent lawsuits are shown to be copyists. Instead, they usually are inadvertent infringers snared by someone else's patent. This problem predates troll activity, but trolls have increased the size of the tax on innovation. How do I know? Let's start by thinking about 4 basic observations. 1, troll activity grew dramatically in the first decade of this century. Trolls accounted for a negligible share of patent litigation in the year 2000. Today, they're pervasive. 2, troll activity is concentrated in software patents, which currently do not work well as property rights. Troll activity is significant. It's insignificant when it comes to the most valuable patents and the most socially important patents on chemical inventions. 3, small businesses have motivated attorneys general in several states to investigate patent trolls. 4, Peter Detkin from Intellectual Ventures thinks troll research validates his suspicions that a lot of people are, I quote, gaming the patent system and that there is a consummate cost to society. Regime change, wisdom of the crowd, and admissions against interest are important sources of evidence that there's a troll problem. Survey and econometric research tends to confirm this conclusion. Jim Besson and I analyzed data from an RPX survey and estimated the direct costs of non-practicing entity or NPE lawsuits to defendants was about $29 billion per year. In other work, we use something called an event study methodology and find that the total costs from NPE lawsuits are about $80 billion per year. Second number is larger than the first number because the second number includes indirect costs, which arise because upstream and downstream firms have business relationships with the target that's sour. Managers and engineers are distracted, and because innovation suffers at the firms while the lawsuit is pending. In a similar vein, a recent study by a Rutgers economist named Roger Smeets examined the effect of patent defenses on corporate R&D. For small firms with fewer than 500 employees, he estimated the R&D intensity at these firms fell somewhere between 2.6% and 4.7%, and the effect persisted for up to 3 years after the filing of the patent lawsuit. He also found that the depressing effect of the patent litigation did not depend on the outcome of the litigation. The harm to innovation was present even when the defendant won the lawsuit. To add insult to injury, Allison and Lemley find that when patent trolls bring lawsuits, where they are looking specifically at frequent patent plaintiffs, they usually lose the lawsuits. The cost to innovators and the tax is still present. The chilling effect of innovation appears to be strongest among small high-tech firms. Chien finds that 55% of unique defendants in PAE, that is patent assertion entity lawsuits, are small firms that make less than $10 million per year. Robin Feldman conducted a survey of 200 venture capitalists. All of the respondents indicated that a patent demand against a patent portfolio could be a major investment deterrent. New research from Catherine Tucker, an economist at MIT, is especially alarming. She finds that patent troll litigation was associated with the loss of roughly $21.8 billion in VC investment over the course of 5 years. She also finds a significant negative effect on the founding of new firms. Some say there are offsetting benefits to the activities of NPEs. In particular, some apologists suggest that they help small patent owners enforce their rights and that better patent enforcement significantly boosts innovation. I see no evidence in support of that view. Let's look back over the last 3 decades during which there's been a dramatic decentralization of innovative activity in our economy. Small patent owners with valuable patents in pharmaceuticals, medical devices, and biotech have, without the aid of intermediaries, been able to enforce their patents, and they've been able to develop new technologies or transfer technologies. If you take a look at successful high-tech startups back from 20 or 30 years ago, like Apple, Microsoft, Google, Facebook, RIM, none of those companies had difficulty bringing those products to the marketplace despite relying little on patents and not having any use for patent intermediaries to help them enforce their IP rights. To sum up, troll litigation is a dramatic new feature of the modern patent system, not seen on this scale since the late 19th century. The problem of abusive troll litigation is widely acknowledged. Troll litigation imposes significant cost on innovative firms, and these act like a tax on innovation. They chill R&D, they disrupt funding of high-tech startups, and there's no good evidence that they facilitate transfer of technology. Congress, the courts, and the PTO all have a role to play in addressing the troll problem and the overarching goal of making software patents more property-like. Reforms that make patent rights and patent assertions more transparent would be a step in the right direction. Reforms that mitigate the harm caused by litigation against innovators who inadvertently infringe are critical. Opponents of reform warn that the reforms will weaken the patent system and cause unforeseeable harms. They made the same warning before the patent reforms in the 1990s, but they were wrong. After reforms were made that discouraged the practice of submarine patenting, the level of patenting continued to grow, and the level of innovation by small high-tech firms continued to grow. Likewise, the same well-funded interest groups drafted amicus briefs opposing the holding chosen by the Supreme Court in KSR and eBay. Same result. Patenting continued to rise, and innovation by small high-tech firms continued to grow. Finally, they cried wolf again before the AIA was passed, but it appears that the modest reforms in the AIA have not stopped the rate of patenting from continuing to grow, the amount of innovation to continue growing. Reforms that Congress are considering are part of what I hope is a package of reforms that will be implemented with the help of the PTO, with the help of the courts, that will make our patent system more property-like and more successful. Thanks.
Thank you very much for that eloquent and succinct summary. So I will turn now to Professor Osenga.
Technology. Sorry. Okay. Thank you for inviting me here today to provide my views on why we don't want or need the currently pending patent legislation, and in particular, Representative Goodlatte's Innovation Act and Senator Grassley's Patent Act. Just a couple of tongue-in-cheek remarks to begin with. I have seen, you may have heard, Goodlatte's called the Anti-Innovation Act, and that would be abbreviated AIA. And we already had one of those a few years ago, and I would like to disagree with Professor Moyer that we don't really know the full outcome of how the AIA has affected, but I'll talk about that in just a moment. And then there's the Patent Act that reforms the Patent Act, which I find a little metaphysical. So I'm concerned about both of those acts, but let me get to the serious remarks of why I am concerned. I want to agree with precisely one point that Professor Moyer has made. There are companies that misbehave when it comes to patent litigation, and that is true. Unfortunately, that is our entire common ground. It's a very, unfortunately, narrow plot. Our areas of disagreement are much larger. To get through them quickly in the time I've been given, I want to frame my disagreements with you using the 5 W's we learned back in grammar school: who, what, where, when, and why. Specifically, who the legislation is aimed at, what does the legislation do, where should patent reform take place, when should it take place, and why are we so dead set on rushing patent reform through right now? The 5W rhetorical device also explains to you my overarching feeling about the legislation. We need to be asking more questions rather than rushing to pass it. Slow down, consider the potential downfalls and unintended consequences, and ask questions of all of the stakeholders, not just a few select companies or industries. The patent system and the innovation economy are too complex with lots of moving parts, and this is too important to rush through. Anyway, my short answers to the 5W questions. Who? The legislation is aimed at the wrong targets. What? The legislation makes it very difficult for legitimate enforcement of patent rights and eviscerates the strength of all patents for all patent holders. Where? Patent reform is already occurring in the courts within existing laws, a fact that seems to be all but ignored by Congress. When? Patent reform should take a deep breath, slow down, so we can see the actual effects of the AIA, passed just a few years ago. The effects of recent court opinions that speak directly to certain types of troublesome behavior, and the FTC's 6B study that's supposed to tell us how these patent trolls really are acting. And then finally, why? Why I think the reason that we are pushing patent reform ahead at breakneck speed is based on bad and incomplete information. Let me spend the rest of my time fleshing these out just a bit for you. Who? Supposedly the legislation is aimed at patent trolls, but there are a couple of problems with this. First, not all bad actors are patent trolls, as we think of them. Some versions and interpretations of patent reform legislation include universities, where some of the highest levels of invention are currently taking place. But they're patent trolls. And also, I read this recently, a 2002 Forbes article that talked about troll-like behavior between IBM and Sun Microsystems. Those aren't the trolls we currently think about, but they behave badly too. The second is the flip of that. Not all patent trolls are bad actors. Now, I don't like to call them patent trolls. I like to call them patent licensing firms. It's a terminology, though, the pejorative, patent troll, captures too many business models that are important in today's innovation economy. Inventions come from a lot of places, but not all inventors can market or even wish to market their products, and so they have to do something else. You may have heard about Edison and Goodyear and how they would be called patent trolls today. I'm going to give you one that people don't think about a whole lot. Henry Phillips. Henry Phillips, back in 1936, patented the Phillips head screw. Fantastic. Got a patent on it, everything was good, and created a licensing company. Didn't make screws himself. It was used in Detroit on automobile assembly lines to keep workers from over-torquing the screws. Apparently that's the whole point of Phillips head screws. I had no idea. But today we would consider Mr. Phillips a patent troll. It's a good thing we like our cars, otherwise we'd be attacking him too. Now what? The legislation is supposed to prevent patent trolls from engaging in bad behavior. But the more likely effect will be to keep good, honest innovators from being able to enforce their patent rights. The same heightened pleading requirements, limited and delayed discovery, and potential for fee shifting that's meant to deter patent trolls will affect innovators, especially those in small or medium firms, to perhaps an even greater extent than patent trolls. It isn't clear that the legislators understand the consequences of these provisions and how widely they could stretch. A better example of what, in my opinion, would be the Strong Patents Act introduced by Senator Coons. It is a very narrowly targeted piece of legislation for specific mechanisms used by the very worst of the patent trolls. instead of this very sweeping patent reform that includes a lot of legitimate patent enforcement and imposes onerous requirements. Where? This legislation is supposed to prevent patent troll behavior, but over the last couple of years, the court has already worked on this. And studies are starting to show that troll litigation is decreasing, not increasing anymore. And the courts are doing this within existing law. They're not changing the laws, okay? And by not changing the laws, they're not creating unintended consequences with wildly broad reforms. So I'm going to give you just two examples. Alice versus CLS Bank. I honestly think it's a lousy opinion, but hey. It seems to have had the effect of invalidating a bunch of patents that are alleged to be overbroad, vague, or just plain bad. There's also the Octane Fitness and Highmark cases. These opinions make it a lot easier for courts to award attorney fees in exceptional cases, cases like when there's bad actors, precisely what is trying to be done through the fee-shifting provisions of the legislation. But the exceptional cases, based on the discretion and determination of the district court, is a lot better and more truly tailored than a vague standard of shifting fees to non-prevailing parties unless the party's position was reasonably justified. Patent law is too uncertain to make that phrase at all meaningful and makes it a little bit scary. When? The legislation is just too soon. A number of provisions of the American Invents Act that were intended to alleviate some of the problems of patent litigation are just now coming to full fruition. We're just starting to see the cases come through, see how they get seen by the Federal Circuit, et cetera. We really don't have a full idea of how the AIA has affected patent law at this point, and yet we're ready to throw it to the side and throw other things on top of it. Another question about timing. Despite the fact that provisions of the AIA are finally getting there, and despite the fact that courts are working to, within existing law, deal with some of the problems attributed to patent trolls, Representative Goodlatte's bill is almost identical to the one that he introduced 2 years ago. It's as though time has stood still, but it hasn't. Things have changed, and so a bill that was carefully tailored would take into account the fact that the patent landscape has changed in the last 2 years. And then finally, with respect to when, the FTC's 6B study on patent trolls is currently ongoing. Why don't we wait for that data? The study isn't perfect. In fact, I have a paper telling you why it's not. But it definitely could shed some light on what really is going on with patent troll legislation, or litigation, allowing legislation to be more carefully tailored and closer to reality. And then finally, why? It seems like, in my opinion, that the reason everyone is rushing headlong into patent reform is that this patent troll idea has grown into a fairy tale and has taken on a life of its own. But the fairy tale is being supported by anecdotal evidence and empirical studies, a number of which Professor Moyer has mentioned. But these studies have also been called into question, no offense to my fair colleague. Okay? Professors Chris Katropia, Jay Kaysen, and Dave Schwartz have done a really nice empirical study that kind of comes out in a different direction. Okay? So in any case, regardless of who you want to believe, if you want to believe the Kaysen, Katropia, and Schwartz camp, or Besson and Moyer, you have to wonder, when there are two separate letters that was sent to Congress, one with a big old group of law professors and economics professors saying one thing, and another letter that says precisely the opposite. One that says the patent troll problem must be solved post-haste, and the other one that says, hey, slow down. You need more data. So if there's that many smart people disagreeing, and since they're all, law and economics professors, they're smart, to me, that means we don't have all the information yet. So again, maybe the FTC study, when completed, could help us out here in figuring out what the right answers are. I'm not against all patent reform, but I am against patent reform that is not narrowly tailored to address a problem that has been clearly identified by solid data. I'm against patent reform that doesn't take into account all of the stakeholders and not just the big guys. And I'm against patent reform that's going to weaken the patent system, which I think is a critical part of this economy. Thank you.
Another good and entertaining summary. Now to somebody who's been in the trenches dealing with patent litigation, Associate General Counsel Jessica Halbert.
Hello, and thank you as well for having me here today. I'm going to start by saying that I'm up here with a slightly different perspective on this, which I think is somewhat clear. This has certainly not been a fairy tale for QVC and a number of businesses that are very similarly situated to us. When I came to the company, almost 5 years ago from private practice, I was actually looking forward to my litigation role coming down a bit. I was excited to work a little bit more on prosecution side of things and work with a company on strategy, and I really thought being a full-force litigator was not going to be part of my day-to-day, and I was unfortunately very wrong. I, like many in the field of intellectual property, had no idea that a television and e-commerce company like QVC was experiencing a steady stream of demand letters and full-blown litigation in this area. I've come to learn over my years at QVC that retail is one of the hardest hit industries by this litigation abuse, and it is being abused. During my tenure at QVC, the company has been directly involved in more than a dozen litigations of this kind, and when I say more than a dozen, that does not include the numerous demand letters and extorted licenses we've been forced to take part in that never actually rose to court litigation. In the intellectual property group that I run at QVC, NPE litigation is our #1 litigation expense, and it's fastly taking up more man-hours than we have to throw at it, both in-house and outside. When it comes to fighting patent trolls, even large companies like QVC are at a massive disadvantage. With little cost of litigation by those who are abusing the system and their ability to vaguely assert infringement, not only in demand letters, but even at the level of the suit itself, we at times don't know the technology that's being asserted against us until we are months along in the process. Despite it being done through gritted teeth, we often find ourselves, like many companies, forced to settle for cost of litigation, not cost of license, cost of litigation, even when we're fairly certain that seeing the matter through will result in a victory for our company. In a specific example, we found it necessary to settle for 7 figures in one patent case, knowing the patents would most likely be invalidated, and they were several years later. But the legal tab of doing that actually outweighed the very large settlement we paid at a slightly earlier stage in litigation. I've heard arguments, and we've already heard touches on it today, that it is big business squashing innovation in our efforts to seek reform of the patent system when it comes to this abuse. It couldn't be further from the truth. I'm standing up here from a company that is all about innovation. We're all about the entrepreneur who's trying to get their invention to market, and we have the ability to bring them into 100 million homes. So imagine how loath I am to also acknowledge that when a company like QVC is forced into settlement in these types of cases, we are often funding the next line of patent troll being brought against the small businesses and the innovators that we are here to support. How are upstart tech companies, application companies, and small businesses that just happen to have an e-commerce side supposed to fight the good fight when it is so costly to do so and they don't have the resources that we even feel stretched using at QVC? The average cost I've read of NPE litigation is over $500,000. Tell me how we're supposed to encourage small businesses to stay in and fight for their rights when one case can put them completely under. I think one thing everybody on the panel can agree upon is that any patent reform needs to get bad patents out of the system and protect continued innovation. Nobody's disputing the need to protect continued innovation. But balanced reform can accomplish this. And if there's one thing I've learned from the troll activity that I've seen before and after the AIA, I've been on both sides of that legislation while at QVC, is that if we aren't careful, if we get lost in the weeds of being too targeted or thinking one small fix is going to resolve the problem, we are essentially creating the roadmap for future abuse. And we'll all be back here arguing again in several years. It is imperative that people willing to push back against this abusive action have a menu of options to do so. This is both in the patent process itself and in the beginning, the middle, and the end of litigation. I don't have time to go through every proposed reform, but to touch on a few and the effect it could have for us, let's start at the beginning of a case. At the beginning of a case, even before it starts, we have demand letters. And then once it begins, we have pleadings. At the earliest stages of the process, all many of us are asking is to know what technology is being asserted against us. QVC has received letters that the only way I could respond to them was to say, you're going to have to tell me more, because we didn't even know what they were talking about. We would research the company. I would actually pay outside lawyers just to do the due diligence to know who I was talking to and what they were talking about. And that's not how a demand letter should be put together. This has continued on into the pleading stage. We had a specific case where QVC was ultimately dismissed because we were already licensed to be using the technology that allegedly infringed the patents being claimed against us. It took us months into the process to find out that there was even a license because we hadn't identified what part of our website they were really trying to get at. When we move to the middle of a case and we move to discovery, this is where you hear a lot of people say the bleeding really begins financially in these cases. When an NPE has virtually no discovery costs, they are in the ultimate position of power. Each month, thousands or hundreds of thousands of dollars can go out the door in these litigations just to survive the discovery process, even if you ultimately know you're working on settlement to try and get a license before you go to trial. We all love the romantic notion of fighting the good fight, but I simply cannot go to a company and ask them to continue on when it is so cost prohibitive to do so and we can settle out at a cost of litigation price tag. If only one side is bleeding in this fight, there's really just no way to survive it. And that brings me to the end of the case. When a case ends, it can't just be in the most rare and exceptional circumstances. Fee shifting must be a real option. The ability to seek fees is an extremely strong weapon against trolling. With most cases never going to trial, and fees being an unlikely award for even the successful parties under the current standard, we do not have a financial pushback. We can't hurt the abusive actors in the system in the best way, which is in their pocketbook. If a company with resources to make it to trial had the strong potential of a fee award against a baseless cause of action brought by a patent troll, not only would we be incentivized to see the cases through, we might even help deter the wrong cases from being brought, or at a minimum, see less of them because it's much more costly to sue a whole bunch of people at once and see what shakes out if all of them could result in getting fees back in the end. It looks like I'm coming up on my time, but thank you again for having me here, and I hope that we can actually see some true menu reform that's going to make a difference and have a patent system that really is supporting innovation. Thank you.
Thank you. It's very good to get the perspective of in-house counsel. I know before my time at BlackBerry paid several hundred millions of dollars in a settlement in a case involving a non-practicing entity. And so obviously the size of some of these settlements and can be quite large, and obviously is a great concern to companies, large, well-capitalized companies, as well as obviously small companies. Let me turn now to a judge's perspective. Judge Michel, who during over 30 years well, at least roughly 30 years on the federal circuit, reviewed many patent disputes, and obviously has a unique perspective. Judge Michel?
Thank you so much, and thanks for organizing and sponsoring this discussion among the four of us, and hopefully before we're done, all of the people in the seats we're facing will be given a chance to participate in the discussion as well, and ask questions and make statements and so forth. I think it's very important to step back and understand what we're talking about when we refer to the patent system or the patent law, what it really embodies and how it operates. In my judgment, the most important player in the overall patent system is not the inventor, it's not judges, it's not litigators, it's not patent prosecutors, it's not any of those people. The most important player or actor in the overall drama is what I will label the money manager. It might be a venture capitalist, it might be a commercial bank, it might be a pension fund, it might be a private equity company, and it might be someone inside a corporation that has a substantial revenue stream. and that woman or man has to decide how much of the revenue stream to invest in research and development. That person also has to decide, and it's even more important, how much money to invest in commercialization. And by commercialization, of course, we mean bringing a new product to market or a new cure to hospitals by actually creating plants and hiring workers to produce that product or that result. So in my view, it's really all about investment, which means investment incentives. Clearly, the corporate decision maker, just like the outside investor, the banker, let's say, has many options. And so the question is, are the incentives strong enough to encourage appropriate levels of investment in research and development, and as I mentioned, particularly in commercialization of already developed innovations? All of those men and women have many options in terms of where they can put the money. So if the incentive to put the money in research and development and commercialization is inadequate, the decision will go in the other direction and the money will be directed to other uses. So for me, that's really what the system is all about and what's at stake in any changes to the system coming from any source, but particularly from further legislation. Since leaving the court 5 years ago, I've had the opportunity to talk with many, many people from other disciplines. I used to, of course, hang around with litigators and judges because that was the immediate world that I lived in. But since leaving the court, I've spent a huge amount of time with many other disciplines, technicians, inventors, business executives, investment community leaders, union leaders, and many, many other disciplines. And what strikes me particularly is the statement by all the decision makers that the one thing they can't live with is high uncertainty. I've been told by business executives in virtually every technology, every type of company, every size company, every sector of the economy, that they would rather live with a rule that's a little unfavorable to them than a rule or a regime that's unclear. Uncertainty is the killer. So then I ask, well, if uncertainty is such a huge problem, so fundamental and pervasive in the whole system, what's the uncertainty quotient now compared to before? So it seemed to me that prior to the AIA, enacted, of course, in 2011 and implemented in 2012 and 2013, so now we have a couple years under our belt. Before that act was passed by the Congress, what were the biggest problems in patent litigation and in the patent system? The biggest problem was uncertainty, too much uncertainty that deters investment. What were the other problems? Litigation of patents way too slow, way too slow, way too expensive, way too disruptive, way too unpredictable. So then we had the AIA, and now we have 2 years or so of implementation of the AIA. So what has happened to those ills? Every single one of them has gotten worse. Patent litigation has gotten more expensive, more delayed, more disruptive, more unpredictable. So this is a concern to me, looking at the overall system. You know, I don't work for any company. I'm not worried about the bottom line. I'm not affiliated with any industry or any coalition. So I don't have to worry about concrete economic pressures. I'm just looking overall at the system and trying to see how it works. Is it getting better? Is it getting worse? It's almost like a health assessment. Is the patient improving or going down? It looks to me like the patient has gone down sharply in the several years since the AIA was passed. Let me give you a few examples. Former PTO director David Kapos and I joined the board of directors of a company that was attempting to create a stock market for patent rights, because patent rights that are only traded and mediated through litigation, very inefficient, as I have said, too slow, too unpredictable, too expensive, and so forth. And lots of licensing that comes out of that is secret. So nobody really knows what the market price is because you can't find out usually what other people pay and so on. So the idea was to create something like the New York Stock Exchange for ordinary securities, where everything would be transparent, everybody would have all the same information, everybody would have the same terms, where the price would be set by the market, just like a stock market. So the organization, it was called Intellectual Property Exchange International, assembled a series of portfolios dealing with prime economic activity and sought to offer those portfolios to people practicing the technologies under these transparent, uniform, non-discriminatory, market-based price arrangements. So what ensued was extensive negotiations with various levels of companies, large and small, but mostly fairly large, over whether they would take licenses to these patents. And some of them were standard essential patents that had been independently vetted by outside experts as truly being standard essential, not the assertion of the owner, but a third party verifying it. So what happened was that in the mid-levels of the companies, they were interested in taking the licenses, and the licenses had the added incentive of a 6-year backward-looking amnesty provision. So permission going forward at a cheap price and erasing past liability. In many cases, the approval went all the way up to the CEO level. And this involved dozens of different potential licensee companies. In the end, even if the CEO approved, the final step was to ask outside counsel, what should we do? And in every single case, the outside counsel told the corporate official, do not take a license, do not negotiate, do not answer letters, do not return phone calls. Even if you're sure you're practicing the invention, even if you're confident that the patent is valid, do not take a license. So this was really quite startling. So we then went and asked a lot of litigators, is that really the advice you're giving to all your corporate clients? And every single one of the ones we vetted this through said yes, that what you're experiencing is now the new normal. So in America, we used to have what I'll call an honor system. For decades, for example, IBM licensed thousands, tens of thousands of patents to innumerable players in the broader economy at a huge scale that yielded several $1 billion per year in licensing fees. And they never had to file a lawsuit because in that era, we had the honor system. Now we don't have the honor system anymore. Now the advice from the outside counsel, and therefore the decision of the decision makers in the companies, is I'm not going to license, I'm not going to negotiate. If you want to sue me, sue me. So the outside lawyers say, if they sue you, call us. Maybe they won't even sue you. If they do sue you, we can probably institute an IPR, and we very well may be able to invalidate some of the patents. We almost for sure can get a stay. The stay will last for about 3 years because the IPR involves a 6-month petition period followed by a 1-year decision period followed by the inevitable Federal Circuit appeal that will take at least another year. So it basically provides for a 3-year timeout in most lawsuits. It also adds costs because every IPR costs between roughly $500,000 per patent, and in many cases there are many different IPR brought against the same patent, and in many cases there are multiple patents. So the $500,000 quickly becomes several million. Now it already takes, on average, more than 3 years to get a patent case tried in America. We don't have enough judges, and that's a whole other problem. So now we've doubled that delay time because of the upfront timeout for the IPR. And we've hugely increased the cost for the patent owner. So now it's likely several million before the district court case resumes after the 3-year timeout, and then several more million. So this is going to have very big effects. It's already having very big effects. The litigators joke among themselves, and a lot of them are personal friends of mine. I'm not critical. They're doing their job. Everybody's doing his or her job. It's the way the whole thing works. But they joke that patent litigation is, they call it the sport of kings. Only the richest, hugest, best-funded companies can participate in the attempt to get justice in the federal courts in the United States because it is so, so expensive. So most of the players, the vast majority of patent owners, can't afford to litigate because it's so expensive. So they're forced to resort to others who have greater funds, and that's how you end up with patent assertion entities and all the rest. So it seems to me we have a problem already of a system that's collapsing. Licensing is collapsing in most sectors, not every sector, not every company. Some people are still licensing, but people who are experts in this field tell me that in most sectors, licensing has collapsed. R&D investment, again, there are big exceptions, is collapsing in most sectors. The result has to be that job creation will be stemmed. The result has to be that less economic growth will occur. Ultimately, if patent portfolio values have gone down as much as I've been told, ultimately the stock value of all those companies will go down too. Most companies in America today, unlike 50 years ago, the assets are mostly intangible property, mostly patents, not inventory and raw materials and factories and so forth. So we have a very big challenge here to try to deal with abuses in litigation and in demand letters, which surely occur, which are reprehensible, which need to be deterred, need to be punished, need to be ameliorated to the maximum possible extent. But the problem is doing that in a way that doesn't wreck the whole patent system for holders of valid patents who are responsibly asserting them. So one of the things it seems to me we need to have is a better sense of proportion. So for example, if almost all patents were invalid, that would tell us something very important about what reforms were needed. If the portion of patents that are invalid is much lower, let's say 5%, that would push us in a very different direction. Or take litigation. If almost all lawsuits were frivolous, then we would know we have a huge problem. If most lawsuits are not frivolous, say 10% are frivolous and 90% are not frivolous, that would tell us something very different. Now, I don't have any idea what the percentage of frivolous lawsuits is that are merely filed that never go through the full court process, because, of course, I didn't see those suits. But I can tell you that from several decades on the federal circuit, the percentage of frivolous lawsuits that I saw was less than 1%. So it makes me suspicious of the idea that most or nearly all lawsuits are frivolous. So if frivolous lawsuits are a vexing and expensive but relatively limited phenomenon, that should be part of the calculus in how drastic the fixes are. You know, if the patient has a broken finger, you don't amputate their arm because that's vastly beyond what's needed. So we have somewhat the same quandary here, I think. So the question is, will the new act now proposed, let's just focus on what I'll call the Grassley bill, the Senate bill recently introduced. That bill, in great portion, not all of it, but in great portion, seeks to micromanage patent litigation as it proceeds from the day it starts until the day it's over. Now, I think it's a little bit preposterous to have members of Congress who are not litigators, not judges, no expertise, no experience, no real insights into the dynamics of a patent lawsuit as it proceeds through its extensive life. So who does have the expertise? Who does have the experience? Who does have the responsibility? Federal trial judges. In 10 years of hearings, leading up to the AIA and now in recent hearings, the number of federal trial judges consulted, called as witnesses, 0. Number of investment community leaders called as witnesses, 1. Number of inventors called as witnesses out of scores of witnesses, 1. Number of university leaders called as witnesses, the great research universities are the backbone of innovation in America, none. So some of the most important perspectives haven't been brought to bear on the problem, the real problem of abuses and the real risk of wrecking the incentive system and killing the investment. So I'm not against patent reform legislation, past or present. I do think some adjustments need to be made in the AIA, that the IPR process is very excessive. Patents that will be held valid in court are being held, and have been held valid in court, are being held invalid in the Patent Office because the standards are totally different. It seems to me the standards ought to be the same. So if I were king of the world, I would revise the AIA and the implementation by the Patent Office to make all of the standards and the process identical in the Patent Office on IPRs as in court. But I would still legislate further, but the question is whether it can be done without destructive collateral damage that could be catastrophic. So it seems to me what Congress ought to do is to consult a broader array of people with relevant expertise, particularly judges and litigators. Litigators also not called in these hearings, oddly enough, because in the end, only federal judges can prevent abuses, can punish abuses, can save costs of discovery, of excess motions, of satellite litigation, and so on. So it seems to me that before it acts, and it should act, I'm in favor of further reform that focuses more on the courthouse than the Patent Office. But it should be done based on a full deck and not a partial deck, which I think is what they face now. So the question is whether the process can be rationalized and improved so that the full wisdom of all of the different disciplines can be brought to bear on this problem. Abusive actors, I guess that's what we mean by trolls. I mean, if we just mean somebody who doesn't make the patent, it's not a meaningful phrase. Thomas Edison didn't manufacture, and so on and so on. But if by trolls we mean people who issue deceptive, false demand letters or file frivolous lawsuits, of course we have to act against them, and strongly, and we should do it promptly. But we should do it intelligently. We should have smart patent reform so that the incentive system will thrive and we'll have more R&D, more commercialization, and we need it desperately because the federal portion of R&D funding is going down sharply, and it's gone down sharply for half a decade now. NIH is 25% down from where it used to be, DOD the same, Energy Department the same. So we need private investment to go way up to not only replace the shrinking public investment, but to provide the job creation that our economy needs and to maintain and enhance our global competitiveness. So we need smart patent reform, and that means there's more work to do.
Thanks very much, Judge Michel. Let me quickly go around the table and get reactions of individual speakers based on what they've heard. Professor Moyer?
Thanks. I agree with a lot of the framework that Judge Michel just advanced for assessing reform. Naturally, you won't be surprised to hear that I disagree with most of his conclusions. I think it's really sad that we see someone thought that it was profitable to set up an organization to exchange patent rights in the way that this failed patent exchange was set up. Because what's that business all about? It's about transferring veto rights. I can stop you from innovating. It's not about transferring technology. When you want to transfer technology related to standard essential patents, you set up a patent pool, and those work. More importantly, when you want to transfer technology, for example, something like a medical instrument or a surgical instrument that is invented by a small inventor, they don't go to intermediaries. They sell their patent rights to Johnson & Johnson or someone like that. It's worked very well. It continues to work well. No intermediaries are necessary. The biotech firms in Cambridge or San Diego or San Francisco, they're doing great. What's the role for intermediaries in those markets? It's non-existent. Amgen, when it was a small company, it was able to enforce its patent rights. Property rights over medical technologies or pharmaceuticals are real property rights, and they work the way that property rights are supposed to. They're not so expensive to enforce. Venture capitalists build the cost of enforcing patents into their funding decisions, and small companies succeed. I completely agree with Judge Michel that we should look at the money man or the money woman. We've done surveys of those people, and when you ask them about pharmaceutical inventions, they put patents #1 on the list as a tool for appropriating value. When you ask people in most other technologies, the research managers, patents are #4 or #5 on the list. Patents are not really very much of a source of value for most technologies, but they're a tremendous cost. That's why patents are discouraging the money people from investing in R&D, because other people's patents are more costly to me than the real value I get from my patents. That's a balance that's out of whack. My book with Jim Besson, 2008, says that in pharma and in chemicals, the patent system is providing a subsidy that these people acknowledge, they recognize. In other industries and other technologies, other people's patents are creating bigger costs than my patents delivered to me. That's why when you survey software engineers, they oppose patents. I don't oppose software patents, but a lot of people being influenced by patents do. We have to be careful. In the mid-19th century in the US and in Europe, the patent system worked poorly because there was lots of troll-like activity, and there was a potentially really dangerous backlash. In Netherlands and in Switzerland, the patent system was abolished. The Eighth Circuit went for years never upholding a patent in the US because they saw the terrible opportunism associated with troll-like behavior in 19th century America. We have to be careful. If we care about the patent system, we need sensible reforms. We've got to do it now, or something very bad could happen down the road.
Very interesting. Let's see. Professor Senga or Jessica Halbert?
So I guess there's a couple things I'd like to address, but I know we have time limitations. But just to piggyback on something Professor Moyer pointed out, that when we as a company are making a decision, when it's an acquisition or where to invest or where to go next, it absolutely has become part of the conversation that we have to ascertain whether or not we're worried about patents in a defensive way. The conversation is much less now about what are we going to get in wonderful technology if we're looking at a company or looking at an opportunity, but what do we have to worry about? Or is this just going to bring another suit? Is this company even positioned to be able to protect us if what they bring in becomes the next big wave of troll litigation? And I do want to take a minute to address the notion that was brought up about the problem getting better and about the idea that we need to slow this down. From a very practical perspective, I obviously disagree with that. The problem is not getting better. When we are dealing with 920 parent NPE companies in 2014 versus about 100 7 years ago, the problem's not going anywhere. And we need to have meaningful reform so that we can get in front of it and protect innovation. And we're not dealing with rational inventors in these troll matters. We're not dealing with someone simply looking to protect their rights. We're dealing with somebody who's looking to, pad their bank account. And when it becomes financially a good idea to come after QVC or any other company, we're going to get another suit. We don't see it coming down the pike because of the area we're investing in. If we're looking at this technology versus another, it's any day could be any suit. It's Friday, it's 10 after 1. I probably should be checking the docket to see if EDECA is coming after us now. They've hit, 60 people on the last couple Fridays, and it's just not going anywhere. And then the final thing I wanted to take a moment to discuss is IPR, because this came up in the judge's remarks that was framed more as a litigation remedy. And I really have a problem with that, because from where I stand, when everybody's saying slow down, let's see how the AIA takes shape for a couple more years, but by the way, we have to get rid of this IPR thing it brought to the table, it doesn't really seem like a very fair and balanced approach to me. And the IPR has never been, I don't think was ever intended to be a litigation type remedy. It is, from where I sit, putting the decision power in the subject matter expert's hands as to whether or not we're dealing with a bad patent when we're still in that administrative process. So the standard should stay with the standard the way it is at the PTO, and especially when there's an ability to amend during that process, it shouldn't switch over to the litigation standard because it's not litigation. And I'm sure everybody else has more comments to add, so I'll stop it there. But.
Great. Professor Osenga.
Yeah, I'd much rather hear questions from you guys, but I just want to make 2 quick points. Actually, probably the same point. I think the thing that's missing in my mind, and I think it goes a lot, no, it's 2 points. It goes a lot to what Jessica is saying is there's nothing in the reform, nothing that anyone's talking about that has to do with certainty. And I think that, part of why companies settle for the cost of litigation is certainty. They're not certain they're going to be able to invalidate the patent even though they know that it's invalid. They're not certain that they're going to be found to not infringe even though they know they don't, because there's just far too much uncertainty. And it's the same uncertainty, I think, that troubles me the most about the fee-shifting provision based on reasonable position. Well, you never know what's reasonable at the courts right now because you have no certainty whatsoever about patent law. So I think that if there's really going to be patent reform that's meaningful and useful, I think that it's going to have to do something to do with certainty. And the only other thing I want to say is the people that you mentioned that are filing 60 lawsuits every single Friday, they would fall into my bad actors. I think we can address them with a smaller, closely tailored thing.
Judge Michel, and then questions from the audience.
Well, just one additional perspective, and that is that every time a comprehensive major bill is passed by Congress that has economic impact, lawyers litigate the meaning of the terms in the bill. We're still just at the very earliest stages of defining critical terms that were contained in the AIA passed in 2011. That process is likely to take another several years. And every time the patent law has been the subject of major revision, it's taken 5 to 10 to 15 years to sort out the confusion and to finally define these terms. So, for example, in the Grassley bill is a so-called customer stay, which purports to define who's a customer and who's a manufacturer, but really doesn't. So it'll end up being 5 to 10 years of litigation where the courts will have to provide the definition that Congress hasn't gotten around to focusing on yet. So my suggestion would be that Congress should provide more definitive definitions of the key terms in all these major provisions of the statute and then pass it, but not to pass it in this very embryonic, underdeveloped form, because the level of uncertainty and satellite litigation that will be required. I mean, every patent trial will turn into 5 different patent trials on who, who's a retailer, who's a manufacturer, was the lawsuit objectively baseless or not. It's not any longer going to just be, is the patent valid, is it infringed, are there provable damages? It's going to be all these other issues. There were already too many issues, too many motions, too much expense, too much delay in every patent litigation.
Questions?
And now we're multiplying it.
Thank you, thank you. I think question right over here.
Yes, I'd just like a little clarity, Jessica, about QVC. So somebody comes, they've got skin cream, they say it'll make you look 15 years younger. You guys put it on your show and people buy it. You didn't make it, and if there's some allegation that this cream is using some other patent or technology, is it just simply because you featured it that your company gets sued? So that's the first part, is a little clarity. Okay. And then if you have, could you speak to the legislation and if you think it will do the job to correct problems?
So first, that's a question I actually get a lot. It's one of the reasons that when I show up at a patent conference, people go, what's QVC doing here? You know, sell skin cream or vacuums or whatever the case may be. But the difference is we're not getting sued on the products of our vendors. When a lawsuit comes in, and I have seen troll litigation against vendors in our company, but that is generally handled by our vendors. That would be a problem they have. That's not a QVC problem. What a lot of people don't realize is that we are a sizable e-commerce retailer. We see almost half of our profits come from e-commerce transactions. The patent troll suits I'm getting are on our shopping cart. I think we've had at least 2 or maybe 3 that just went to the shopping cart technology, search mechanisms on the website, ways for transferring data. We were brought into the Maxim litigation, which really went to mobile wallet technology, but because of the fact that we have smartphone apps and we are multi-platform, we were brought into that as well. It is our technology that's being threatened by the suits. As for the legislation, it's a little early from my vantage point, to say something is absolutely where it needs to be. There's lots of talking points from all the parties who have interest that I think are still going to be weighed. We still have markups to go through, but the underlying theme, I guess, that I always come to the table is we can't get lost in the weeds. We can't decide that if we just fix demand letters, everything else will be fixed as well. We really need to take a look at this and say, can we be reasonable? Can we protect innovation? And can we give multiple options and avenues to be able to prevent this type of suit? I don't want to see the legislation create a workaround because it didn't actually give enough of an option for means to combat trolls.
I think a question right up front here.
Hi, Andrew Kloster. I'm here at Heritage. So a two aspects to the same question. The question is about political externalities. So some people say that with this legislation down the line, some of the aspects of litigation reform, however you want to describe it or characterize it, could be applied in other non-patent, non-IP areas, such as fee shifting, et cetera. So number one, prospects for swing for the fences, tort reform down the line. Okay, but the second, which I think maybe you're all more equipped to answer, is other IP reform coming down the line, and what sorts of reforms are other IP areas such as copyright or trademark, particularly maybe Professor Murr, as problematic as patent? I mean, are there trademark trolls, copyright trolls? How can we deal with that? You know, there's some suggestion in the patent legislation for covered customer sort of protection, maybe end user copyright protection. I don't know. I'm just saying, like, what sorts of things that, if they occur in today's patent legislation, can then be expanded to other areas of IP?
So you were right in predicting I had no particular insight into the first question. So sorry, no answer there. But second question, there could be some spillover. There are similar problems. There are trademark bullies. There are copyright trolls. The magnitude of those problems, though, is relatively small. In copyright law, independent creation is an absolute defense. In patents, it's not. So when I independently create something without knowing about the technology that's been patented by some other party, because I can't see the patent at the time that I'm introducing my technology, I don't know who the owner is, I don't know what the scope of the right's going to be. All of those are problems for me that make it likely that there could be inadvertent infringement. when it comes to both trade secret and copyright, independent creation is an absolute defense, so you don't have to worry about the issue there. With trademark, we do have potential for something similar to happen, but so far, the magnitude of the problem is relatively small. I like your question because we need to keep an eye on intangibles. As our economy moves more and more toward intangibles, and as we continue to use property rights to protect intangibles, these sorts of notice failure problems are likely to continue to be large. So mainly it's a patent problem today, but the thinking that when we have intangibles, and if you want to use a property system to incentivize people to produce them, we need to work hard to get the property system to work right.
Look, what's happening here is an attempt to have different rules of civil procedure for patent cases than every other type of civil litigation. If we go down that track toward balkanizing procedural rules and rights of parties in litigation, how long will it be before tax lawyers or antitrust lawyers or mass toxic tort lawyers or you name it want to have separate rules favorable to one part of the economy versus another? Once you start down the track of micromanaging lawsuits and having special procedural rules just for one category of case that benefits certain parties and disadvantage other parties, Congress is going to be drawn into this in every area, and you're going to have chaos in the courts. It's going to exacerbate all of these problems. And at some point, it really raises a constitutional issue of separation of powers. The judiciary is supposed to be a separate, independent, co-equal branch of government. But if Congress overthrows 80 years of letting the judiciary decide procedural rules through an elaborate mechanism they have that includes the Supreme Court, and instead is going to micromanage not just lawsuits, but the rules by which lawsuits are litigated, I think we're on a road to a very bad place.
Question back here.
Yes, I have a question related to joinder. I'm an independent inventor. I'm the bottom line of what's being affected by all this new patent legislation. I do understand, coming from a corporate perspective, that you believe that there's a problem on your side. Well, there's a major problem on our side as well. The only thing when we invent something that gives us the motivation to invent is the fact that we have patents to protect what we're inventing. And when we approach a larger company, the chances of that being taken, as Judge was saying earlier, is quite high nowadays. Basically, you assert a patent, you state that you want to license it or sell it, it's a legitimate patent. Everything that you're saying is assuming that everything is not a legitimate patent. What is the protection for us? And so as an example, with the joinder procedure in both the House's bill and the Senate's bill, and loser pay, well, who's more capable of paying? You guys, who own a multi-billion-dollar corporation, or me, the little inventor? What's going to prevent, or what's going to protect me? And so with the loser pay, that's one of the questions. The other thing is, and just one last question, which I'll address to the judge, doesn't the joinder procedure, which allows you to go after investors of the asserting entity, isn't that, in other words, if the investor invested $25,000 and the total fees that were litigated were, say, $10 million, that investor can suddenly become liable for much more than his investment. Doesn't that have something to do with piercing the corporate veil, and does that not undermine all corporate law as well?
Shorter answer is yes.
And I'll respond to your question about the inventor. And first, to be fair, nothing's been decided on yet, but when it comes to fee shifting, nobody's suggesting it's without a standard. If somebody is able to bring a case and there was a legitimate reason to bring it, particularly an inventor who has rights in that technology, I know without a doubt we're not just, when I talk about lawsuits, it's not only trolls that are involved in lawsuits, But the ones that are coming to us in this manner with vague asserted threats, with abusive discovery practices are trolls. They are interested in getting cost of litigation settlement. And having a standard on the back end that would separate out and have a fee-shifting deterrent possibility for somebody who is a bad actor and was not, to pick one of the standards there, reasonably objective in their actions, is not the same as saying loser pays the second you get to an end of a case. So I think that is an important distinction to be made. And there's also, QVC as a company takes licenses to legitimate technology. When we purchase and license legitimate technology frequently. We may not, at the size of our company, do a lot of dealing with individual inventors because that pairs a little bit better with other types of corporations than what we do. Our individual inventors come in and sell. So we make our deals with our individual inventors that way. But I don't want to give the impression that we will never license technology from anybody legitimately, but the cases that are landing on my desk, the Friday afternoon worry I have, is not an offer for licensing. And something we do as a company is if I ever receive a letter about licensing, I at least figure out who I am dealing with. And I have the ability in the council to help me figure that out. And I can determine pretty quickly whether we're speaking with somebody who is an inventor or licensing a technology that could be useful to the company versus somebody who's looking to extort a license in lieu of litigation.
I think we're sure, but we're sort of time constrained. I think we had one more question, but very quickly.
Why would the universities, majority of universities, why would the majority of pharma, why would the venture capitalists all be against this legislation if everything is correct?
I would actually argue that that's not necessarily the case. I believe the AAU actually is showing general support, at least for the Patent Act at this time. I think there is an absolute intention and desire by everybody who is advocating this sort of reform to make sure there is a carve-out and not an undue burden. The abuse that's going on with the hedge fund gentleman against pharma right now, I think people are brainstorming and wanting to see that resolved. It's an abuse on either side.
I think we're going to have to move ahead, unfortunately. I had one last question very quickly.
No.
Okay, let's finish up then. Let me let you finish up then.
The legislation is entirely in favor of the big companies the fee shifting. Just about every provision in it favors the big company. And so why does a small inventor have to go to, quote, a patent agent? And the interesting thing is that if you look in the real estate field, we don't call real estate agents real estate moguls. Yet in the patent field, when somebody's trying to sell a patent as a representative for an inventor, then you work one of them patent trolls. Everybody's getting called a patent troll. I'm probably a patent troll. If you want to interview a patent troll, here I am.
Okay.
I'm an inventor.
Yes.
Okay.
Software technology. I actually do produce software.
Okay.
So I think the proposed legislation will be a boon to small inventors. Someone like Lazaridis, who invented wireless email, got a patent on wireless email, set up the company that Alden worked at called RIM, making the BlackBerry. He didn't make much money at all from his patents, but he sure paid a heavy price when there were 4 other people that held patents on wireless email, and one of them successfully sued him. The people that want to sell their technology to Cisco or Johnson & Johnson get less money for their technology and their patents because of the problem of patent trolls. The innovation tax means there's less money to hand to the small innovator. And on top of that, as Jessica was saying, the small innovators are relentless targets of these troll lawsuits. That's why the app developers are pulling their hair out. They need some kind of protection from these patent lawsuits.
Alden, I'll make a prediction, even though it's always hazardous to predict the future when we have so much trouble understanding the present and the recent past. I predict that the Patent Act will create more and larger patent assertion entities.
Okay, well, on that interesting predictive note, we'll have to quit. And I want to thank all of my panelists for an outstanding discussion and for the audience for some very good questions. Thank you very much. We're adjourned.